It's notarized on June 2017. So,
7 days later.
yep. So it's, well,
Earlier.
the recording, there's a lag on recording time. So it's notarized, then it's sent in, certified mail, then they record it. So there's some lag on that. That's okay. But this mortgage has been assigned. So I'm like, okay, fine. So then I go and I look at there's a substitution of trustee. That's in July. So a month later. And turn the page, and I'm like, wait a second here. So on the page, it's notarized on the same day by the same person. You seen that? So page 151 is my actual assignment of the deed of trust. This is from the bank changing it to another bank. And then, and it's notarized same day, same person. Substitution of trustee. When it goes to substitution of trustee, that says, hey, this person's not making their payments. We're going to substitute the trustee now for a foreclosing attorney. And so that's what they're doing. They're substituting it to, lo and behold, Quality Loan Service Corporation. Where have we seen that before? On this guy's house. When we're looking at Chase. They're the ones that are doing it for Chase. They're a foreclosure mill. This is all they do. So same day. So on the second page here, you'll notice that I have everyone is the same notary, same person signing, which is kind of crazy because Ashley Mays is the notary. Tiffany Chambers is the assistant vice president. The question that I have though is, if she's the one that is the assistant vice president, and this was assigned to another mortgage company, how come she's signing it? Let's go back and look at the document again. This is where it gets really, really crazy. Is the substitution of trustee.
Right? So, I'm sorry. The first document, the assignment of deed of trust, that goes from one bank to another.
Yep.
They're selling the debt.
Yep. So here's what happens. So we go to the assignment of the deed of trust. This is the original bank, the original lender. You can see there's a MERS information. There's a MERS MIN number and all that stuff. So everything was transferred electronically with MERS. Then we show up, and then Ditech now owns this loan, or they're the ones that are foreclosing. They're the ones that are the servicers of it. So I have this assignment of deed of trust, and when you actually read the document itself, let me see if I have it on this page. There you go. So on page 151, you're not going to know this if you don't know what you're looking for. So on page 151, guys.
So I'll re-record it. I'll look it up later.
Very first paragraph read the very first paragraph after it says Ditech is getting the property.
All interest and rights accrued or to accrue under that certain deed of trust dated 8/18/2015, executed by Zachary Baroni and Brooke Baroni, husband and wife, as trustors to Chicago Title Company, as trustee and recorded as instrument number XXX on
Yeah.
8/26/2015 in book, whatever, number.
Yeah.
Official records in the official county record of Sacramento, California.
So that's when Ditech took this over. Was that day. So what they're saying is like, oh yeah, it was assigned to us that day, and she's notarizing it when?
2 years later.
2 years later, man. They made this document up in order to justify their foreclosure.
Oh.
They don't have standing until they create this document that says, oh yeah, we have standing, Your Honor. This is our standing right here. Well, why was it executed on 2015 and then not notarized until 2017? We'll get back to you.
That's what happened in court?
We didn't go to court because of that.
He didn't realize it.
We didn't go that far. It was dismissed. I got a lien release. Or not a lien release. They forgave the debt, the foreclosure debt. Only reason why this guy still has his house.
That guy you were talking about that didn't make payments?
Yeah. He's making payments out of the bank. They just release, move forward.
So he owns it for
No. The foreclosure proceedings stopped.
But how many foreclosures do we see where they don't even have this?
Dude, I don't know. So much fraud out there.
Is this something
That's what I'm
that we
saying,
need to
so
watch?
these guys like tried to cover the tracks, most guys don't even try to cover their tracks, right?
Like I said, in the future class, we're going to get into it. I'm going to show you some deep, deep, deep stuff. Like robo-signing, all kinds of stuff.
Wow.
I have, yeah, I just, we,
Disturbing on so many levels.
it is.
Yeah, you know, that's all you can say.
There's,
Wow.
there's rampant fraud, and it's going to distract us from getting into our firm foundation of what we're here for. But just keep in mind that it's coming, guys. And this is,
Wait, I mean, if you haven't already, wait till you talk to a family who's getting screwed by these banks, who literally, like, they're giving them the runaround and just crazy stuff, and they're taking their house the next day, and
So how come there's less regulatory teeth going after these guys for this kind of stuff?
that's a fair question. And the reason for that is, especially in judicial states, is you have a lot of judges that are sitting on the bench that their retirement, guess where it's put in? It's in Wall Street. It's in these bank stocks, these portfolios. So if these banks take a tank, what happens to their retirement? They're slitting their own throats. I can tell you some stories off camera from an attorney that has taken this all the way to the Supreme Court and what happened to the judge who actually took it to the Supreme Court and ruled in this attorney's favor. Huh?
Lunch story.
Lunch story, guys. Yeah, it's,
So question on the house that we just looked at.
Yeah.
The title. So if it's only showing her right now,
so what we don't have, great question. So what we don't have is county records. So this is where you got to go back and do a grantor grantee search, because there's I guarantee there's a quitclaim deed from him to her, because she's shown up on title. We don't have all the information from First American. They just have transfers from like grant deeds. If there's a quitclaim, which is him giving his interest to her, that's why it's going to show up that way.
okay, like on Property Radar, it shows that $13,500 quitclaim deed family.
Into a joint, correct?
To
To a
joint.
joint account.
So you're saying there's possibly another one where he gives it all to her?
Well, that wasn't a quitclaim. That was actually a grant deed. That's why they paid the taxes on it. That's why it's $1,350, because that was the difference in taxes.
But yeah, he's saying there could be one where he gave it to her after that.
Where it's just
He
a quitclaim only.
released his interest.
and that wouldn't be in Property Radar.
No.
So the 13,000, that was just the taxes that they paid?
Yeah. Yeah, the transfer to bring her on board. Now it becomes a new sale. It's now,
Okay, so when she,
because they're not married. If they were married, it would have been interspousal, wouldn't have been an issue, because he's adding someone else onto it. It's a new transfer according to county guidelines, so they can go ahead and tax that as a sale.
oh, okay, as a sale.
As a sale, yeah.
At the assessed value?
Yep.
Or he really wanted to add her, if he's gonna bet 13 G's on it.
Well, no, he's just being taxed at that rate.
He must be
Yeah, he's not dishing out 13,000.
So what does that 13,000 mean?
That's just the difference in what he bought it for what they assessed it as.
Oh.
They're
he's
upping
getting
the assessed
additional
value,
13,000.
Yeah.
So it got raised.
So if you remember, like this, so it's 5 months later. So if you remember what was happening in 2005, he bought it for $260. 5 months later, oh, this is now worth $275, $273. Yeah, whoop, throws it in there. So the county's gonna get paid. Like, oh, we're gonna pay on this guy.
They're reassessing.
They're reassessing it at the new value because it's new ownership, is what it is. And
And then if there's a spousal,
spousal doesn't matter. You can take your spouse off as you wish. Interfamily transfer is what it's called.
so you can add her or take her
Is that the
off?
same with the trust?
Same thing as a trust, yeah. No taxes. Yep. All great questions, guys. Cool. All right. So next step on this would be just to call the guy and see what he wants to do with it, or call her and see what she wants to do with it.
Can you do that now?
Sure can. So foreclosure defense is what it's going to be. And we're going to see, and based on what Eric said, it's pretty, the guy's not happy at all, he's not friendly, so he may or may not answer, but let's just go ahead and go with it.
But we want to talk to her though, ultimately.
Um,
Her name is on it.
She's the one that's on title, yeah. And Eric just left. Because I don't have the guy's phone number.
You didn't want to have to leave in midstream.
Yeah, I guess not, huh? So we'll call this guy up. And I'll throw him on speakerphone. You guys can hear what he says. Here I handle it with the guy. Sometimes you strike out. Sometimes you're like, all right, let's make this happen.
Okay, this is not striking out, this is less than one for us.
Of course it is. Yep. Hurry up, Eric.
Here, will you look up an address?
Mhm.
911 Baker Hill.
In where?
Teal.
In First American?
Yeah,
All right. So what is it again?
911
Okay.
Baker Hill
I'm gonna try to get it on Monday.
in Rockland.
I have it.
Okay, I got it.
Yeah,
And what am I looking for?
Yeah.
That one shows the titles, correct?
Yeah, Paulina and Mario Flores.
911 Baker Hill,
Mm-hmm.
should be.
Yeah. Is that it?
Oh, 910. Let me.
Oh, 910?
Yeah, try 910.
Sure. Diane Colby?
Yes.
All right, that's the default.
So nobody steal this just in case.
I think we're among friends here.
Okay, so this app will show, what is it gonna show me?
What do you see?
So you got the
Okay.
APN, you got the square footage.
I mean, versus what you're looking at on property radar.
Yes. I'm looking at titles.
So title. So you see who's on title right now. It's Diane.
Okay,
So this app gives you is it's going to give you the property profile. It's going to give you who's on title. It's going to give you all the transaction history, and it also will give you comparable sales.
so see transaction history.
Okay, transaction.
Access to all the documents too, which is huge.
Well, and that's,
Yeah.
those documents I had to go up to,
Property radar makes you pay for it.
well, and because I had to go up to the county and look for them.
She's been having problems for a long time, dude.
Right, and there's the one that it's James and Sally Plessinger.
Well, they owned it, and it looks like they sold it to her because. Yeah, but where's the debt at though? That's the question: is who owns the debt?
The debt is owned by the father that passed away.
Okay.
Um,
2000.
So James,
So James Plessinger and Dorothy Plessinger are the parents.
are you guys seeing this? You guys following this?
Okay, they are the parents. Dorothy passed away.
Okay.
Okay, so James now has all of it.
All right. So it's a title issue, probate issue. Let's take a look at this. This is a good thing. So
How would I know if it's been probated?
well, here's what I'm saying is we're going to look at how it's being held on the grant deed. How they're holding. So it's joint tenant. No, this is so. That's who bought it. Yeah. So they bought it. Looks like they bought it right here from Signature.
In 05.
No
yes.
vesting type,
So I'm gonna check out the vesting type on it right now.
look in the document,
So vesting, guys, is husband and wife as joint tenants.
so right of survivorship.
No right.
No right as joint tenants? Tenants in common is the one you gotta divide up. Am I wrong?
Search the internet for California joint tenants right of survivalship.
Let's,
Here's what I found on the web for California joint tenants' right of survivorship.
Without.
Search the internet. Does California joint tenants have the right of survivorship if not stated? Question mark.
Okay, I found this on the web for does California joint tenants have the right of survivorship if not stated?
I read this one time on, it was actually First American Title. They have the whole breakdown of all of the title vestings. It's like a PDF form.
Oh, that'd be awesome.
Super, super, super helpful. And
yeah, right of survivorship for citizens.
the right of survivorship is an important legal right that allows property ownerships to keep property in the event of co-owner's death. Property held as joint tenancy by the entirety or common community property with the right of survivorship automatically passes to the property owner without going through probate process. There's a difference between joint tenancy and community property with right of survivorship. Blah, blah, blah. So California, most married couples hold property as joint tenants with the right of survivorship. Joint tenancy is a type of co-ownership of real estate and personal property between two or more. So yeah, what I understood from the title company, and we'll probably have to verify this, is that you have to specifically state right of survivorship with joint tenancy.
Wow. Yeah, because in the middle there it says because joint tenancy creates a right of survivorship.
that what it says?
In the middle of that paragraph.
Okay.
Which would make more sense.
Third way down.
I got you.
Tenants in
When a married
common
couple-
Own an equal but undivided part. and
On
you
the
can
death of the spouse, his or her interest will automatically pass to the surviving
Pass that
spouse.
to your kids. your-
Okay.
Your portion.
So here's where we're at then on this. So for argument's sake, let's just say joint tenancy, husband dies, it's now the spouse's. But it's not the spouse's. You know why? You have to file an affidavit of death. Because if I want to transfer ownership, I can't transfer ownership as the wife.
Right.
I need both signatures to transfer. So without filing an affidavit of death and having that on the public record, I don't have the right of that survivorship yet.
So if you go to, I don't know if First American will do it, but if you're there or you go to the title or the county and you don't see that affidavit of death filed, then you know that it hasn't been properly.
Right. She can't convey title.
Which means she's the owner of the debt.
Well, not only owner.
Isn't the heat? Isn't
Yeah,
it's the
Oh, the
father's
dude.
still-
Oh, the
was-
father's still alive.
The
Okay.
father was the one still
So
alive.
he in order to transfer any kind of title and do anything, he has to file that affidavit of death.
Okay.
with the county.
You can't
Yes.
file it for him?
You can create it for him and file it for him.
Yeah, it's a notarized document, right?
It is a notarized document, yeah.
And so then
So-
anybody can go record it.
Yep.
As long as the county may say, well, we have an issue with how this is written, and they send you back and have to fix something.
So he has it. So
So here comes the conundrum.
all right. So
Scroll down. It goes to a joint tenant here now. He added
his daughter.
his daughter and her husband.
When did he die? When did she? Okay. So let's pull this
Okay.
up. Husband and wife, joint tenants. So they're both granting to Kevin and Sally Thornburg,
Mhm.
husband and wife as joint tenants, all as joint tenants. So they're all joint tenants now. All
So-
four of them are joint tenants on the property.
So, okay, so survivorship is still valid,
For argument's sake, let's say yes.
okay?
Okay.
Okay, so,
Who's this Diane lady?
okay, this is the other sister that actually lives in the home.
Diane Colby. So this is an invalid deed.
Because there's not all four signatures?
Yes, this deed does not count.
Yeah.
If this house were to be sold in the open market, this is a clouded title issue.
And I want this house,
Okay.
But we-
okay? Well, and right now there's a Liz Pendants active. And I need to find out who actually owns this house.
On public record, because the county does not do, they just record, regardless. Whatever you give them, they will record it.
Right.
So that's what they did here. They don't verify any
They
of that
don't
stuff.
care,
Nope.
yes.
So James cannot add her to the grant deed without the other four parties' signatures, other three party signatures.
She owns nothing.
And a certificate.
She owns nothing.
She owns nothing.
How is she, okay, because she shows up on title just because of this.
Because of this.
But it's not legit.
No, it's not. Because they didn't go through a title company.
Oh my
They just created it and threw it out there.
Okay.
I can't see, is she the only
You
one?
excited?
She is the
I'm
only.
very excited.
She is the only
This
one.
is a big fucking payday for me.
Are you glad you came?
Pardon my French, guys. I know.
Just for me. Wait, is this a good thing for you? Because you're in contact with her.
I can't tell. You excited?
He's shaking, he's sorry.
I literally am. Okay, so Sally Thornburg and her husband own this house,
Correct.
okay?
Plus dad.
Because dad passed away.
Oh, dad passed.
So you need
Okay,
two
got it.
So
affidavits. of
dad
death
is now
filed.
passed away.
Got it.
They too own this house.
It's a mess now because you have a clouded title issue.
Right.
But
And
you can get this expunged because it's not proper.
So
You get a corrective deed.
I would need an attorney to do this?
A quiet title action is what you're going to need to do. But in the meantime,
Go talk to the real owners.
you go find who they are. These Thornburg people.
I have everybody.
You have everybody.
I have everybody.
So what's the
Copies
challenge?
of
What's the
it.
challenge that you're facing right now?
Because,
Diane wants it?
Diane believes she owns 50% of this home.
Yeah.
Sally and her husband believe she only owes a third.
This is where joint tenants come in, see, yeah.
And so they're both fucking wrong. I'm sorry, guys. They're both actually wrong. There is actually an attorney, and the two girls were both realtors. And one is still a realtor. It gets better because Sally's attorney told me he wanted a $25,000 down payment.
What's the debt on this house? It's going.
And
It's in default, man.
It's in default, so I can't do that. He wanted me also to guarantee a certain amount to Sally. I can't do that either. And so, I mean, obviously the attorney doesn't know what he's talking about. She doesn't know what she's talking about.
Or he's just trying to work it.
So, I need to get a hold of Sally, and we've already said what she will take, and we came up with a number. This is the $405,000. If I pay her that $405,000, and she will get the number she wants, which will make her a happy camper, which will also mess with her sister, which will make her an even happier camper, which it's sad to say, but this will make her ecstatic.
These are the sisters you talked about yesterday?
Yes.
Yeah.
I've been working on this house for 4 months, and I've talked to the attorney, I've talked to Sally, I haven't talked to her husband because they're divorced or getting divorced or something, and I've also talked to,
You haven't talked to her husband, but her husband's on title, right?
correct, and I don't know what happened with the divorce there, obviously he's still on title,
Yeah.
and there hasn't been anything to do with it. But this house, the house, ARV, 650, 670.
So what I would do, I can't give you legal advice, can't give you real estate advice, can't give you any advice. But if I were in your shoes, what I would do is this. I would go to whoever is on title, not as county records, but per the land records. If dad is dead, they are now 50-50 owners of that property. Each, or collectively as a whole, 100%. If I have an agreement that they're going to give me that cash or whatever, I would have each of them sign a quit claim deed, relinquish their interest in that property to me. And then I would go ahead and start the process. We're going to have to I would bring it current. I would, because I'm going to lose this property, to the bank, which is going to wipe out all title issues, or all questions of who of ownership is. I would bring it current, and I would then go through a quiet title action. It could take several months to do, but in the meantime, I would put a renter in there or somebody to fund my litigation for me.
And you said the one woman's living in the house?
Yes, so I
So you
will,
have to do an
You'd have to
eviction?
do an eviction, yeah. If she's been there more than 2 years, or more than a year, it's a 60-month notice.
60 days.
Sorry, 60-day notice, 2 years, yeah. It's a 5-year notice, guys, yeah. No, 60-day notice, and then you have to, after the 60-day notice, if she doesn't get out, then you start the eviction process. Another 60 days, 75 days.
So what about her 405 number, assuming the ex-husband, soon-to-be ex-husband even agrees to that number?
Now what you can do is you can go to title and open up escrow, and they can do a prelim report for you. And they're going to tell you, like, oh, we have an issue.
Yeah, they'll point it out.
Yep.
Nice.
which we already know there's
Yeah.
an issue.
Yeah.
But here's the thing. The law states that if someone has been in the property for 60 days, or for a year or more, you have to serve them a 60-day notice. If your intent is to move into this property, that law no longer is valid.
What do you mean? Oh,
30-day
Not
notice.
occupied.
If you want to inhabit your own house.
30-day notice.
So it just goes to 60 to 30, but you still have to do an eviction?
Still do an eviction, yeah. But you save yourself 30 days.
But you could also offer cash for
Cash for keys.
keys.
and I.
But it sounds like she has an attorney that wants $25,000.
No, that's the.
Well, and that's not the sister that's there.
Oh, okay.
That's the sisters that's in the Bay Area.
I gotcha.
And
Oh.
so
Palo Santo.
the sister that's living in there, yes, I would probably have to.
That's the one that has a-
Is there a will?
I believe so.
You need to find that out.
Oh, dear.
Can the will trump it?
The question then
It can
becomes,
trump his third.
it depends on what the, well, no, because the rights of survivorship transfers over to those people. So what does the will say though? Upon my death, my assets go to, but if he's already transferred his assets out of his name by virtue of adding people to joint tenancy with him, then you can argue the fact that this will even pertain to this property anymore.
So this is a good time to have a lawyer friend.
Definitely. This is a probate issue. It's a quiet title issue. I have an attorney, Jay Freeman, Sacramento. He can handle this one for you.
I mean, it's a big, beautiful home.
It's worth the money. It's worth the money to invest in this and get it going.
How do we know? Do you know what repairs are?
I've been to the house, I haven't been in. I know that all the carpets are pulled up because she has dogs. So I know it's gonna definitely, all carpets, it's gonna need a full paint inside and out, sorry. And just minor updating. I mean, it was built in 2005, so I mean, it's, you know, it backs up to a green belt, it needs landscape to be fluffed up.
The numbers work though.
Yes. If I do it at 405, considering my rehab as a high number, it actually ends up being about 65, 68% that I'm purchasing it at.
Okay.
Are you using, what if you did it the 15%
So
way?
what's the loan on this?
200 and some odd thousand.
So yeah, 185 is the published bid. So why not just go to the auction?
I don't have cash.
Find a partner.
Well, no, and actually the bid, that's where I was asking you this other question yesterday.
Yeah.
The published bid is 405. Unless it's changed.
See, I'm looking at the notice of trustee sale. It says the initial publication of the notice of trustee sale is 185,330.
Okay, and that one, it's been postponed and it bumped up on one of the postponements.
So yeah, I would take the TS number, the trustee sales number, and I would call them. They won't tell you the opening bid. Well, you know what? What does Property Radar say?
What's the arrears on it?
It says 405, about 30-some thousand.
30-some thousand?
Yes.
So this is, just for me to clarify, this is
Yeah,
complicated
this is 50,
because
that's less
you
than
can't just
10%.
go put it under contract and get the signatures because two of the people are dead, you need affidavits of death, there's a clouded title, you're gonna have to do a quiet action
I don't,
suit.
I
So all those
don't
things
actually know.
complicate being able to wrap it up under contract and then sell to a buyer.
Personally, I don't know. Yes, if I could get Diane Colby,
No.
Sally Thornburg and her husband all to sign, that'd be great. I could cover my bases with everything.
That's right. Yeah.
But Sally is, I think, speaking for her husband, right, or ex-husband, doesn't wanna sell. She wants it.
She wants to lose it?
She thinks she'll get more money at the auction. and-
Oh, in surplus funds?
In surplus funds.
Oh, please.
And she also thinks.
Do you all understand that, guys? Do you want to?
And that's where my, I know she won't get that.
So
because
explain
she-
surplus funds for the people that don't know.
So between what's the loan amount and what allegedly it's gonna sell for at auction, that's the surplus funds. Problem with that is, that's the bank taking it that. They're also gonna start now detracting whatever it costs to do the foreclosure and all of their fees and everything else.
Because they're gonna try to keep as much of it as they
So,
can.
they're gonna jack up and say, this is how much it costs us to do that. So she now looking at maybe 3-something, whatever. And she's a realtor. I mean, if you look at her up, I mean, she's got this nice, does big homes down in the Bay Area and everything. But obviously, she don't know shit from Shinola. And that's, you know. and
So Property Radar has this as an ETAL.
this is,
So it says Diane Colby ETAL.
what's that mean?
Multiple people and others.
Yeah.
And others.
And that would be
Yep.
that would be the Sally and her husband, the Thornburgs.
Right.
And then they show the auction bid.
Property Radar has a published bid is 185,330.
It's changed. Oh, keep going down then.
Yeah, that's it.
Foreclosing loan amount,
Whoa, that's changed.
160.
Okay, published bid.
That's what I'm saying, like, man, go bid it out, man, and it clears title for you completely. You don't have to hassle with it all. I'd go to them and say, look, I'll either give you guys some cash so you can get some money, or I'll go take my chances at the auction for 185.
There'll be a few people there.
There definitely will be a few people there.
Yeah, that
But
neighborhood
thi-
and that community.
But this changing from and that's where her thing was, the 405, that's where, what she was.
This is on Wilson's birthday. Oh no, the day after.
If that's changed down to back to that, I don't know
24th,
where
yeah.
they had gotten a 405.
That's it. That's awesome.
Did you ever see 405
I did see it.
on auction.com?
I saw it on Property Radar.
So the foreclosing loan amount is 160. That's all the late fees and penalties and everything for 185. Look at this, guys. The lender is Deutsche Bank. These guys, so Deutsche National Bank, trust care of. This is a trust. This is a MERS account. This is definitely a fraud account on this one. But again, you're not going to do some foreclosure defense on this. So there's too much equity in it. You're not going to screw around with that. So okay. So learning experience. What did you learn from this?
Actually going to the
Reading
courthouse steps
documents
as
is
an option?
gonna be helpful.
Reading documents is extremely helpful. Going to the courthouse, definitely.
And I've been to the courthouse and I pulled every one of these.
Okay.
And that part of what it is I didn't understand the in common and everything else. So now that I know that the dad owned it with the two people, and so he died, they now own it in title full, and the other one to Sally is null and void because it wasn't signed by all three.
So what is the document that signed it over to Sally?
It was a grantee.
It
It's
was
just a grantee.
Yep.
And it was
But-
only signed by the
Father.
father, by the father.
Let's see who prepared
And
it.
that went to
But
Diane,
can't-
not Sally.
But can't,
Yeah.
the child give their dad and mom's birth certificate and file that?
Their death certificate.
So
Yeah.
that gave it to Diane.
So that would give them.
Correct.
Not legally.
Supposedly, he wanted to give his portion to his other sister, his other daughter. And so that the two daughters would have 50-50.
So if she becomes a tenant in common, it's legal that way?
He wanted to give his portion. So let's assume he did that in the will, right? Let's assume he gave
So that would
he
only
gave his full third
33%.
interest.
But it has to state specifically what he's doing, and it doesn't say that. Like, he's not saying I'm granting 1/4% or whatever of my interest to my daughter. Like, and that does happen, and you will see that when they're doing that. This doesn't say that. It's just saying that I'm giving everything I own to all my interest in this property, everything I have is given to my daughter.
So quick
Oh,
clarify.
so he's saying his interest,
No, he's just saying
the whole property.
everything.
Yeah.
He's acting as if him.
So he made a mistake there, but let's say in the will, he says all, my full interest in the property.
Oh, hang on. Go ahead. What's your question?
So if there was 4, one dies, they all 3 now have 33%, right?
Yes.
Okay.
So hang on, guys. I misspoke. Check this out. Diane Colby, his daughter, his interest, including the interest acquired as of August 16th, 2012, at the death of my beloved wife, Dorothy, blah, 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 my beloved, or his beloved wife. Who wrote this, man? In the property described specifically. So
So he's giving her 33%.
she now has, she actually is
Ah,
on title.
so she is on title.
Yeah.
I think-
You have to dig into these things deep, man.
I think she becomes a tenant in common though. I don't think you can give a survivorship right this way.
Well, there was no survivorship right because he was still alive and he transferred it to her.
But she can't join the current situation as a joint tenant.
No, I see what you're saying. Yeah, no, he can only give her interest.
Right.
His interest of what he has in that property, which would be a third, because he invited other parties onto it.
But the other two haven't died, so that doesn't matter.
Even if they do die, she doesn't get their.
Right.
Um,
So what you're saying is she's tenant in common, The other two remaining are now joint tenancy, so if one of them dies, they get 66%.
Yep.
He
Yep.
still gets 33.
It's complicated.
It gets crazy, yeah. So, throws a wrench in your story. But I still would take the chance with the auction, man. I'd find a partner, be like, I got a sweet deal. I'll do the rehab. You put the money. Let's do it.
And then you're gonna have a fight with other people, because this is a public auction now.
It's
Sometimes
you don't know, man. You buy the auction all the time, don't you?
Yeah,
Yeah.
I walk in there and get a bit of penny over and walk away with, gold mine, just like, yeah. Yeah, I've got one coming up that I saw it's gonna be walking into 150 grand if I'm lucky. I don't know, we'll see. And this one's like that.
And does that happen where there's 150 in equity and
It
nobody shows
happens.
up but
It
you?
happens. Yeah.
Just depends on the day.
It just depends.
Huh.
You never know.
I mean,
That's cool.
you saw, there was one in San Francisco, and basically they bid on an easement, and it's for, in a court, and it's the easement for the road, is it?
Yeah, Lombard Street easements for all the cars to get into the parking lots, into the
And-
driveways.
And and it's for some senators and everything live on that, use it. Well, they bought the easement,
Now they're charging everybody
and they bought it dirt cheap.
for nothing.
Almost, yeah, it was almost nothing, it was
100,000 or
insane,
something.
insane,
At public auction?
at public auction.
Oh yeah.
And nobody
The,
showed up.
the Asian couple.
Yes.
It's Diane Feinstein Street.
Yes.
Yeah.
It's awesome.
$900,000 he's charging them to release his easement lien.
And they bid it at dirt cheap.
They got like
So
35
anyone
grand.
could-
It
Yeah.
was like $35,000.
Anyone could have bid on it,
Yes.
Anyone could've
Yes.
bid
but
on it.
nobody showed up.
But nobody knew it.
Yeah,
But
they
these
didn't
two
do their
people,
homework.
these people, they
You
did
gotta
their
do
homework and found it.
Yeah.
And that's,
Still opportunity
So
on
what
the
happens,
courthouse
so
steps.
they in charge of going back and forth through it?
yeah, they own that property and now you wanna cross it?
You wanna use it to get to your property? Yeah, it's an interesting one.
It
It's
really is.
It made the national news.
It did. All right, guys. So, how many of you guys feel like when we're talking about title, that this is what you're looking at?
Scribble? Pretty much, Chinese.
Tenancy in common, joint tenancy, community property. It's all Chinese to me, guys. I don't have a clue. I'll get you this right here. This is what I was telling you about fidelity. Common ways of holding title.
Yeah.
So what Gary was saying is, check this out. So where did I lose it at? Oh, joint tenancy. So going down to upon death, on co-owner's death, his or her interest ends and cannot be disposed of by will. Survivor owns the property by survivorship.
That's joint tenancy.
That's on joint tenancy.
So he can transfer it before he dies, but if he waits till he's dead, his will can't do anything.
That's right.
That's correct.
Yep.
Wait, say it again?
So
If
he
he's alive, he doesn't transfer his interest.
So that,
But once he dies, he can't.
His will can't do anything for him. If he's
I'll make sure you
alive,
guys get this.
Yeah, thank you.
he can't do
Of
that.
course, definitely.
Or
He
limited
can't
joint
will
Not
his
if it's
interest in
joint.
a property that's joint.
So what
Not
about?
if it's-
as soon as he dies,
Curious,
the
Ryan?
other
Not a
tenants
trust.
own it now.
You have a trust?
100%.
so this actually,
Not family
I mean, it really
Yeah.
screws.
Not after his death.
It's
So
different.
His will can't do anything for him.
It's different. Yeah, you're
Once
fine.
that's like
The trust owns it.
While he's
Because I
alive,
have
he's
he does it through the title
Family,
process.
in the family trust.
Yeah.
And it sounds
So I'm going to put this under evaluate, guys. Just make sure you give me your things.
What drives that?
No, they used to be.
big slide.
There we
You
go.
have that in a, what did you share with me? Dropbox? Do you have it in
Yeah.
Dropbox?
Yeah, I can put it up there too. Yeah. All right, I think this is a good stopping point for us to go have lunch. Let your brains kind of just relax a little bit.
I can't relax, man. When I can't sleep, I'm just so
What's going
fired
on
up.
with this? I'd like to purchase it.
615 C Street.
Yeah.
And then, so it ended up the trustee, the beneficiary for the trustee was gonna be Placer SPCA. SPCA said, well, we're gonna defend this, we're gonna bring it up current so we can sell it at a real market value. So I kinda got screwed on that one.
PCA, I'm sorry, what's that?
SPCA, the animal,
Yeah.
yeah. You know, it's good because, I mean, they got their money, but it went for more than what I think it should have.
All right, you got it?
Yep.
All right, what's his homie's phone number?
530-913-8500.
Really? James.
Hello, this is James.
Hey, James, this is Ryan. I was calling about your house on 615 C Street.
Ryan.
Oh, yeah.
It's not my house, and I'm not interested.
Oh, okay. Whose house is it?
It belongs to Space.
Oh, okay. Because when I looked up on public record, it still had your name on it.
Well, that may be, but it's in foreclosure, and they're little farting around, and I don't want to have anything to do with it, but thanks for the call.
Hey, no problem. You take care. Oh, there it goes.
Seems to be in the same mood I left it in.
So they're fiddle farting around. That's a technical term.
So can't you say, what, you want to just sign over your interest?
It's not in his name. It's
Oh,
in,
right,
it's
you
in,
wanted the wife's.
it's in title. Yeah. So I got to find.
So could you have asked him, hey, do you
No, it's
have
in both.
so-and-so's number?
No,
Yeah,
no,
it's
it's only in hers.
And that's why I was wondering, why, how come you didn't say, well, it's in her name, do you have the contact information?
Let's call him back.
Most of the
Well,
time,
wait.
they won't give it to you.
I know they don't.
But
So she's right. My experience has shown, but I probably should have done for an example for you, but my experience has shown is that if the guy's telling you he doesn't want nothing to do with it, he doesn't want anything to do with it. He's not going to be a party to someone else doing something with it if he's on title. He wants to get it out of his name. Or not on title, but like the credit documents. I can call him back. Why not?
on the document,
It's a
it
nose.
wasn't there a deed that put both of them on?
No, when we looked, it just has Cheryl.
Do we have her number?
I'll call back. Watch.
That's what we,
There you go. No, he won't. That's okay. I'll leave a voicemail.
Slide Island every day.
No.
Thanks for calling James Cahey. Please leave a message. I'll call you back as soon as possible. Thanks a lot.
At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options.
Hey James, this is Ryan. We just spoke. You know what? I was wrong. I actually looked up the information again, and you're right. It's actually not in your name anymore. It's in Cheryl's name. You wouldn't happen to have her phone number, would you? Go ahead and give me a call back or text me 530-755-7552. I'm looking to give you guys some money for this house. I am interested in buying it before it goes to auction with the bank. Thanks. All right, there we go.
I like that, the way you said, you know, if you tore that wall down, say, hey, you're right. That no one's gonna wanna say,
One thing I noticed about Ryan, he's so good at moving just with whatever is, like both when he's talking to
Like
sellers
water.
and buyers, yeah, just like water, and just with obstacles that come up, it's like nothing even just phases him. He's just like, okay, that's the new reality. I'm moving with that now.
That's right, guys. Shoot him a text.
Yeah.
Hey James, comma, this is Ryan, period. We just spoke a minute ago, period. I just double checked my records and you are right, period. You are no longer on title, period. You wouldn't happen to have Cheryl's number, would you? Question mark? Smiley face. Let's see what he says. F off, you loser.
okay, it's better, right now it's a no. Unless you ask.
So, what about this grant deed that says, that gives joint tenancy to both? I, James Cahey, and unmarried man hereby remise release and grant to James K. Hean, unmarried man, and Cheryl Vester, an unmarried woman, as joint tenants.
That's 13,500 thing, right?
Yep.
So maybe there's one that hasn't been filed.
That's what we're talking about.
Yeah, just gotta be quick deed.
Quick claim.
Name is the one that's on it.
Yep.
Somewhere there's something.
Check you out, man.
There's something.
Getting a firm grasp on it all.
Nah, I wouldn't.
Yeah, so somewhere there's a piece of paper floating around.
All right, let's do one more, guys. So, I know I told you, I got all excited. We're going to go to lunch.
No, this is good.
Yes.
Absolutely.
So, I don't know who this guy is, but he texted me this morning. And since we're calling people, might as well call this guy.
It kind of feels like, you know, me being in my office at home, this is what I do.
Yeah.
Chase this stuff down. It's nice to have you all around.
So it says, hi, Ryan, I got your email. We may consider a rent-to-own arrangement on our house in Clipper Mills. Let me know what you propose. We are firm on our price at $190, however, Larry Buck. Okay, guys, I don't have a clue who this guy is. My VA, I told her what I needed to do, so she goes after, you know, Craigslist and FSBO, for sale owners, stuff like that. So she sent emails to people like, hey, would you interested in doing it in a for rent-to-own kind of thing? So apparently this guy is, and he wants his price.
This is probably Craigslist.
Probably is. I have no idea. My VA hasn't sent me my update yet on what it was,
But
but
he also said however. So there, obviously he's
No,
not
he's-
100% firm.
No, he wants to sell it. He wants his price though.
I'll give him his price. That's fine.
However,
You might not be
what?
firm on terms.
Yeah.
Yeah,
It
yeah.
was-
Firm on price.
He meant that however after the
How-
statement, not
yeah.
before the statement.
So-
You don't know what the
So I don't know what the house is. I don't know anything. So I'm not going to call this guy back because then I'll be like, well, didn't you send me the email? Did you see the house? I'm going to go do some research. So after lunch, we'll go try to find out what this house is at.
Awesome, dude. I love how you got that lead off automation. That is sweet, sweet, sweet.
Yep. Oh, I wanted to talk to you about something actually. Oh, yeah. So check this out, guys. So when you're dealing with a property that you're going to be doing a foreclosure defense on, what was that guy's reaction? Y'all remember?
Pretty defensive.
He's pretty defensive, right?
I don't want anything.
So he wasn't going to do it. When you're doing a foreclosure defense, you actually have to have the person who has the debt in their name on board as the party. If he's like, no, I don't want anything to do with it, all right, cool, man, thanks. Like you tried like to maneuver, but the guy says, no, I don't want anything to do with it. Don't pursue it. You can't do anything. You can't be a party to a lawsuit if you're not the party that's involved with the debt. That make sense? So this particular guy was like, no, I'm good, you know, don't want it. Also, he had discharged his debt obligation in a bankruptcy. So now if all of a sudden he decides like, oh, you know, forget that debt, that bankruptcy, I'm going to go ahead and now file a lawsuit against my lender, that debt that he discharged could now come back on him. Because part of the bankruptcy proceedings is like, look, I've surrendered this property. But now if you're fighting the bank on it to defend this foreclosure, you haven't surrendered it. And now what are you fighting if you surrender the property? So you got to be careful when you're coming into situations like that. If someone says, look, I discharged my obligation of the debt or I've gotten rid of the debt in a bankruptcy, it's best just to let it lie. If they haven't done that, yeah, engage them in that opportunity. So
But you can still take over the debt.
you can buy the property from him. You're just not going to defend it. Because if you're defending it,
That one strategy.
yeah, that's just, I would take the foreclosure defense completely out of the equation at that point.
Since that one was 54,000,
To bring it current, yeah,
we're not gonna.
not even going to try it.
Is there 10%?
Exactly.
There.
Exactly right. So this is me. I wrote to the guy, hey, James, this is Ryan, blah, blah, blah. It says, I double-checked my records. You were right. You are no longer on title. You wouldn't happen to have Cheryl's number, would you? She's with me now and does not accept your call. She is not on title. The bank is. Do not call me again, please. So then I wrote back, not a problem. Thanks for letting me know you're not interested. Take care. Left it at that. That's it. All you got to do. Nothing more than that.
That's when to walk away.
I walked away.
Occasionally they'll call you back, yeah?
No, this guy I doubt. What is he gonna do? In his mind, the bank owns the property.
Yeah.
Now, I could have wrong information, maybe the bank does own the property, and I'm just here because the title information is outdated. Do you guys remember what the auction date was on that property?
A long time ago.
And that's when I called up the trustee and gave him the number and find out if it's been taken care of or if it's
I think it
not.
was July 17th or something?
I thought originally it was February, then it got postponed.
No,
to
I
August.
thought it was still there.
A lot of times you'll find out that people, as soon as they move out, they think the bank owns it, and you can't convince them otherwise.
True.
Yeah, I run into
Could you
that
put
so
a
many
link
times.
in your text to information?
Public information.
Well,
Um,
you sent to him and you said, just in case I realize you're not interested, cool, here's a link.
To give him some information.
Give him some additional information on the process.
You might need to check this out.
No, I mean, if I feel there's an opportunity for me to do something, yeah, I have done that. I've screenshotted this notice of default and sent it to the person. I mean, this notice of default was just filed in May, so this isn't gonna be off the auction block until like, gosh,
June,
6
July.
months.
Yeah.
No, 6 months from that, so in another 3 months.
5/2.
August 8/2, so it's 9/2, September sometime is when you're gonna see this.
Yeah.
So, yeah, he called me back and I just was like, oh, you know what? Should tell you guys about this.